In a legal malpractice case, the plaintiff must prove that his attorney deviated from an applicable standard of care for professional conduct. In states that recognize the locality rule, the standard of care varies, depending on the customs of the local community in which the attorney practices. Vermont was one such state, until it abandoned the locality rule in Russo versus Griffin. Joseph Russo owned a paving business in Rutland, Vermont, and wanted to transfer it to his sons, Tony and Frank. So they hired Vaughn Griffin, an attorney who practiced in Rutland, to assist with the transfer and the incorporation process. For the next 3 years, Tony and Frank held their annual corporate meetings in Griffin's office. Eventually, Frank decided to leave the business and sell his corporate interest. Frank and Tony met with Griffin to discuss the matter. During that meeting, Tony agreed to buy Frank's interest in the business, and Frank agreed to resign and transfer his stock to the corporation. Griffin never advised Tony about whether Frank should sign a non-competition agreement. 3 months later, Frank started another paving business in Rutland, directly competing with Tony's business. Tony then sued Griffin for legal malpractice. At trial, Tony presented 2 expert witnesses, both attorneys with law practices in Burlington, Vermont's largest city. They testified that Griffin deviated from the standard of care required of Vermont attorneys by not advising Tony to demand a non-competition agreement from Frank. Griffin presented 2 other expert witnesses, both attorneys with law practices in Rutland. They testified that Griffin's conduct conformed with the standard of care required of attorneys in Rutland. The trial court accepted only the testimonies of Griffin's experts, holding that because those attorneys practiced law in Rutland, they were more familiar with the local standard of care in Rutland. Accordingly, the trial court entered judgment in Griffin's favor. Tony subsequently appealed to the Vermont Supreme Court.